Good day everyone. Today's lecture focuses on copyright and patents, and more broadly on the legal foundations that govern libraries, archives, and information services in Malaysia. This is not a law class in the strict sense. Instead, we are looking at how law shapes information work, what we can collect, preserve, copy, digitize, and provide access to. Every information professional, whether working in libraries, archives, or digital information services, operates within these legal boundaries. In this lecture, we will cover four main areas. First, we will discuss why law matters in information services. Second, we will look at 5 key Malaysian acts that govern information. Third, for each act, we will examine its background, objectives, effects, and implications. Finally, we will integrate all 5 acts to understand how they operate together across the information lifecycle. By the end of this lecture, you should clearly understand that information management is never legally neutral. Why law matters in information management? Law plays an important role in information management. Libraries and archives do not operate in a legal vacuum. Every decision about access, use, and preservation of information is shaped by law. First, libraries and archives are legal institutions. They may appear open and neutral, but they carry legal responsibilities. For example, when a university library provides access to theses or digital databases, it must follow copyright law and license agreements. If copyrighted material is copied without control, the institution, not the user, can be held responsible. Second, information access is regulated, not absolute. Libraries support access, but the law sets limits. For example, an archive may deny access to certain government records because they contain sensitive or personal information. Even if a researcher requests access, legal restrictions must be followed. Third, digitization does not remove legal responsibility. Digitizing materials does not make them free to use. In fact, digital materials are easier to copy and share, which increases legal risk. For example, digitized photographs may still be protected by copyright or privacy laws. Finally, legal awareness reduces institutional risk. When staff understand copyright and data protection rules, they avoid legal mistakes. This helps institutions prevent lawsuits, financial penalties, and reputational damage. In conclusion, law matters in information management because it guides responsibility, protects institutions, and ensures access is lawful, ethical, and sustainable. Information does not appear and disappear randomly. It moves through a clear lifecycle, and law intervenes at every stage of that lifecycle. First, information is created. This includes books, articles, reports, data, and records. At this stage, law protects creators through intellectual property rights. Next, information is published. Whether in print or digital form, publication is regulated. Publishers must follow legal rules on ownership, licensing, and responsibility. After that, information is deposited. Certain materials must be deposited with national or institutional bodies. This ensures that important publications are not lost. Information is then preserved. Libraries and archives must protect records from damage, loss, or unauthorized destruction. Preservation is guided by legal duties and retention requirements. Finally, information is accessed and used. Access is allowed, but not without limits. Use is regulated by copyright, privacy, and ethical rules. Each stage of this lifecycle is governed by different laws. Together, these laws form a complete legal framework. That is why information professionals must understand the law holistically, not as separate or isolated rules. There are 5 core acts that govern information in Malaysia. First, the National Library Act. This act establishes libraries as national institutions. It supports the development and preservation of knowledge for the country. Second, the Archives Act. This act governs records and evidence. It ensures that official records are preserved for accountability and national memory. Third, the Deposit of Library Material Act. This act ensures that published materials are collected at the national level. It prevents the loss of Malaysia's intellectual and cultural output. Fourth, the Copyright Act. This act controls copying, reproduction, and dissemination of works. It balances creators' rights with lawful access. Finally, the Patents Act. This act protects technological innovation. It encourages research, invention, and economic growth. Together, these acts regulate access, preservation, control, and innovation. They form a complete legal framework for information management in Malaysia. The National Library Act 1972 was enacted during Malaysia's post-independence nation-building period. Before this act, library services in Malaysia were fragmented and uneven. Most systems were inherited from colonial structures. There was no single national authority responsible for coordination or long-term preservation of intellectual output. This act was introduced to address those gaps. Its main objectives are to establish the National Library of Malaysia, to preserve the nation's intellectual heritage, and to promote access to information across the country. Through this act, libraries were formally recognized as national infrastructure, not optional or secondary services. The National Library Act has several important effects on how libraries operate in Malaysia. First, libraries are legally recognized as public institutions. This means libraries are not informal service units. They operate with legal authority and public responsibility. Example: when a public library receives government funding, it must justify how collections are acquired, preserved, and made accessible. Decisions cannot be made arbitrarily. They must align with national objectives. Second, the Act defines library materials very broadly. It includes printed books, audiovisual materials, and digital resources. Example: when a library digitizes old newspapers or rare books, those digital files are treated as official library resources. They must be managed, protected, and maintained just like physical collections. The implications for professional practice are significant. Libraries must provide access responsibly, not simply provide unlimited access. Example: a library may allow students to view digital materials online, but restrict downloading or mass copying to comply with copyright and license terms. Libraries must also manage digitization carefully. Example: before uploading digitized materials to a public website, librarians must check copyright status and usage rights. In short, the National Library Act gives libraries authority and recognition, but it also imposes legal responsibility and accountability. The Archives Act 2003 was enacted because Malaysia faced serious problems in records management. Before this act, many public records were poorly managed. Some records were destroyed without approval. Others were lost, misplaced, or never properly documented. Example: in some government offices, old files were discarded during office relocation or system upgrades without checking their legal or historical value. Once destroyed, these records could not be recovered as evidence. As government operations became more complex, records were increasingly created in digital form. Emails, databases, and electronic documents were produced daily, often without clear rules on storage, retention, or disposal. Example: official decisions were sometimes communicated through emails, but these emails were not archived systematically. This created gaps in accountability and documentation. The Archives Act was introduced to address these risks. Its objectives are threefold. First, to regulate the entire records lifecycle, from creation to disposal. Second, to protect records of legal, administrative, and historical value, so they can serve as evidence and national memory. Third, to establish Arkib Negara Malaysia as the central authority responsible for records and archives management. Through this act, records are recognized as national assets, not temporary administrative documents. The Archives Act 2003 has a direct and serious impact on how records are managed in Malaysia. First, the Act legally recognizes records in all formats. This includes paper files, digital documents, databases, and official emails. Example: an email that records an official decision is legally treated as a public record. It cannot be deleted casually, even if it looks informal. Second, unauthorized destruction of records is a criminal offense. Records cannot be destroyed simply to save space or reduce workload. Example: if a department deletes old files during a system upgrade without approval from Arkib Negara Malaysia, this action may result in legal penalties. Third, the Act establishes clear accountability. Archivists, records officers, and public servants are legally responsible for how records are created, stored, accessed, and disposed of. Example: if important records are lost due to poor storage or weak digital security, the responsible officers can be investigated and held accountable. The implications for professional practice are clear. Records management is no longer a technical or administrative choice. It is a legal duty. Organizations must implement proper records policies, follow retention schedules, and ensure secure and authorized access. In short, the Archives Act transforms records management from routine paperwork into a matter of legal compliance and public accountability. Before 1986, many Malaysian publications were lost. This happened because deposit relied on voluntary contribution by publishers. Why was this a problem? Without legal deposit, publications could disappear permanently. Small publishers, private organizations, and short-run materials were often not preserved. Once a book went out of print, there was no guarantee it would survive. Example: local newsletters, community reports, conference proceedings, and government-linked publications were frequently lost after a few years. Future researchers had no way to access them. Another key reason for legal deposit is national memory. Publications reflect Malaysia's history, culture, language, and development. If they are not collected systematically, the nation loses its intellectual record. Legal deposit is also needed for bibliographic control. Bibliographic control ensures that published information is systematically recorded, organized, and made discoverable, rather than scattered or forgotten. Without mandatory deposit, it is impossible to know what has been published, by whom, and in what form. The Deposit of Library Material Act was introduced to address these problems. Its objectives are to preserve national published heritage, support national bibliographic control, and impose mandatory deposit obligations on publishers. Through this act, deposit is no longer optional. It becomes a legal mechanism to prevent national information loss. The most important effect of the Deposit of Library Material Act is that legal deposit becomes compulsory, not voluntary. Publishers are legally required to deposit copies of their works. This ensures that publications are not lost over time. Example: a commercial publisher, a university press, or a government-linked organization must deposit copies of books or reports produced in Malaysia. Failure to do so is a breach of legal obligation. The act applies to print, non-print, and digital materials. Example: printed books, CDs, DVDs, e-books, and digital publications are all subject to deposit requirements. However, it is important to understand that deposit does not transfer copyright ownership. Example: even though the National Library holds a deposited book or e-book, the author or publisher still owns the copyright. The library cannot reproduce or distribute the work freely. The implications for libraries are critical. Custody does not mean ownership. Deposited works are not public domain. Access must still comply with copyright law. Example: a library may allow users to read a deposited book on site, but cannot digitize it or upload it online without permission. This act clarifies the boundary between preservation responsibility and copyright control. Copyright is a legal right granted to creators of original works. It gives creators control over how their works are copied, shared, and used. Copyright exists automatically once a work is created. Its purpose is to encourage creativity by ensuring creators are recognized and rewarded. Before 1987, Malaysia's copyright system was largely based on colonial-era laws. These laws were outdated and no longer suitable for a developing, knowledge-based society. At the same time, Malaysia experienced rapid growth in education, publishing, and media industries. Universities expanded, books, journals, and broadcast materials increased. Later, digital technologies made copying and distribution much easier. Because of these changes, Malaysia needed a modern copyright law to regulate the use of creative works more effectively. The Copyright Act 1987 was introduced with three main objectives. First, to protect creators' economic rights, so authors, artists, and producers are fairly rewarded for their work. Second, to protect creators' moral rights, including the right to be acknowledged as the creator and to prevent misuse or distortion of their work. Third, to regulate reproduction and distribution, while balancing public interest with creators' rights. This balance allows education, research, and library services to function without undermining intellectual property. Copyright protects original creative works. This includes literary works such as books, journal articles, reports, and theses. It also includes artistic works such as photographs, drawings, posters, and illustrations. In addition, it protects audiovisual works such as films, documentaries, videos, and recorded lectures. For example, a university textbook, a photograph displayed in a library exhibition, and a documentary video stored in an archive are all protected by copyright. They cannot be copied, uploaded, or shared freely without permission. Copyright protection also applies to digital and online content. E-books, online journal articles, websites, digital images, and streaming videos are protected in the same way as printed materials. For example, an article downloaded from an online database or a video posted on an educational platform is still protected by copyright. Being available online does not mean it is free to use. Most importantly, Copyright protects the expression of ideas, not the ideas themselves. Facts, concepts, and theories can be discussed freely. However, the specific wording, images, layout, or presentation of those ideas is protected. For example, a student may explain a historical event or scientific theory in their own words. But copying sentences, diagrams, or images directly from a book or article requires permission. This principle allows learning and research to continue while respecting the rights of creators. Copyright law has a direct impact on how information is managed in libraries and archives. First, copying and digitization are controlled acts. This means copying a book, scanning an article, or digitizing a photograph is not automatically allowed. For example, when a librarian scans a chapter of a textbook to share with students, that action is legally considered copying. If it exceeds what is allowed under the law or license, it may be an infringement. Second, uploading material is treated as communication to the public. Once content is uploaded online, it is no longer private use. For example, uploading a scanned article to a learning management system or a library website makes it accessible to many users. Legally, this is the same as publishing or broadcasting the work. Finally, copyright infringement carries legal consequences. For example, unauthorized copying or online sharing may lead to takedown notices, legal action, financial penalties, or reputational damage to the institution. In many cases, the library or organization is held responsible, not just the individual user. These effects show that copyright law directly shapes how libraries digitize, share, and provide access to information. Copyright law has important implications for libraries and archives. First, digitization in repositories must be controlled, not open by default. Libraries cannot digitize and upload materials freely. For example, a library may digitize theses or rare materials for preservation, but restrict online access to authorized users only. Digitization is allowed for management purposes, but access must still follow legal limits. Second, license compliance is mandatory. Many digital resources are accessed through license agreements. For example, an online journal database may allow reading and limited downloading, but prohibit mass copying or sharing outside the institution. If license terms are violated, the institution, not the user, may face penalties. Third, user education is essential. Libraries must guide users on what is allowed and what is not. For example, students may assume they can upload scanned readings to social media or messaging apps. Librarians play a key role in explaining lawful use and preventing unintentional infringement. Finally, it is important to understand that access does not mean permission. Just because a user can view or download a resource does not mean they can copy, share, or redistribute it. For example, a user may access an ebook through the library, but cannot distribute the full content to others without permission. These implications show that libraries and archives must balance access with responsibility, ensuring information is shared lawfully, ethically, and sustainably. Fair dealing is a legal concept within copyright law. It exists to allow limited use of copyrighted works without permission, so that education, research, criticism, and review can continue. Without fair dealing, learning and scholarship would be severely restricted. Every quotation, reference, or classroom use would require permission, which is not practical. However, fair dealing is not a free license. It is a legal exception with conditions. Each use must be assessed to determine whether it is fair. There are 4 key considerations. First, the purpose of use. Fair dealing usually applies to research, private study, education, criticism, or review. For example, copying a small portion of a book for personal study may be fair. Copying it for commercial distribution is not. Second, the amount copied. Using a small portion is more likely to be fair than copying a large part. For example, copying a few pages may be acceptable. Copying an entire book is usually not. Third, the effect on market value. If copying replaces the need to buy the original work, it is not fair. For example, scanning textbooks so students do not purchase them harms the market. Finally, consider the nature of the work. Highly creative works require greater protection than factual materials. Fair dealing balances access and protection. It supports learning, while still respecting creators' rights. The Patents Act 1983 was introduced to support Malaysia's goals of industrialization and technological development. As Malaysia moved towards a more industrial and innovation-driven economy, new inventions began to emerge in areas such as manufacturing, engineering, agriculture, and technology. Before a proper patent system, inventors had little protection. Their inventions could be copied easily, which discouraged research and innovation. Because of this, Malaysia needed a legal framework to protect technological inventions and give inventors confidence to invest time, effort, and resources into innovation. The Patents Act 1983 was enacted to meet these needs. The first objective of the Act is to encourage innovation and disclosure. Inventors are given temporary exclusive rights, but in return, they must disclose how their invention works. This allows knowledge to be shared and built upon in the future. The second objective is to promote economic development. Patents support industrial growth, attract investment, and encourage commercialization of new technologies. The third objective is to balance monopoly rights with public interest. Patent protection is limited in time. After the patent expires, the invention becomes available for public use. This balance ensures that innovation is rewarded, while society ultimately benefits from wider access to new technologies. Patents protect technological inventions. This includes both products and processes. A product can be a physical invention, such as a new medical device, a machine, or a specialized tool. A process refers to a new way of doing something, such as a manufacturing method or a technical procedure. For example, a new type of water filtration device can be patented as a product. A new method for producing cleaner fuel more efficiently can be patented as a process. Patents also protect technological solutions. This means the invention must solve a technical problem, using technical means. For example, an improved battery design that lasts longer or a new agricultural technology that increases crop yield can qualify for patent protection. However, patents do not protect ideas. Simply having an idea is not enough. For example, the idea of a faster engine or a smarter system cannot be patented unless it is developed into a specific technical solution. Patents also do not protect knowledge itself. General knowledge, scientific principles, or abstract concepts remain available for everyone to use. For example, a scientific theory or mathematical formula cannot be patented on its own. In summary, patents protect practical technological inventions, not ideas or knowledge in abstract form. The Patents Act has several important effects on how inventions are used and shared. First, a patent grants a temporary monopoly, usually for 20 years. During this period, only the patent holder has the right to make, use, or sell the invention. For example, if a company patents a new medical device, other companies cannot manufacture or sell the same device without permission until the patent expires. Second, patent documents are public. Although the inventor receives exclusive rights, the details of the invention are disclosed to the public. For example, patent specifications published in patent databases explain how an invention works. Researchers, students, and engineers can study these documents to learn from existing technologies and develop new improvements. Third, commercial exploitation is restricted. Others may understand or study the invention, but they cannot use it commercially without authorization. For example, a university researcher may read and analyze a patented process for research, but a company cannot commercialize that process without a license from the patent owner. These effects show that the Patents Act balances innovation and access. Inventors are rewarded temporarily, while society gains knowledge and long-term benefits. The Patents Act has important implications for libraries and information services. First, libraries provide access to patent information. Patent documents are public records, and libraries play a key role in making them discoverable. For example, libraries provide access to patent databases where users can read patent specifications, drawings, and claims to understand existing technologies. Second, libraries support patent searching and patent literacy. Patent documents are technical and complex, so users often need guidance. For example, librarians may help researchers or students learn how to search patent databases, interpret patent classifications, and check whether an invention is already patented. However, libraries do not authorize exploitation of patents. Providing access to patent information does not mean giving permission to use it commercially. For example, a library can help a user read a patented process, but cannot allow a company to manufacture or sell that invention without a license from the patent owner. Finally, research and study use is generally allowed. Users may read, analyze, and learn from patent documents for non-commercial research and educational purposes. For example, a student may study patented technologies to understand how they work or to design new, non-infringing innovations. In summary, libraries act as information gateways, not licensing authorities. They support learning and innovation while respecting patent rights and legal limits. Information management must be understood as a connected lifecycle, not as isolated activities. At every stage of this lifecycle, law plays a role. At the creation stage, information is governed by copyright and patent law. Copyright protects original expression, while patents protect technological inventions. This ensures creators and inventors are recognized and rewarded. At the publication stage, copyright law applies. Once a work is published, its reproduction, distribution, and communication to the public are legally regulated. At the deposit stage, the Deposit of Library Material Act becomes relevant. This law ensures that published materials are systematically collected so that national intellectual output is not lost. At the preservation stage, the Library and Archives Acts apply. These laws require libraries and archives to safeguard materials and records as part of national memory and accountability. Finally, at the access stage, all 5 acts operate together. Access must respect copyright limits, patent restrictions, deposit conditions, and archival regulations. This integrated framework shows that professional practice in libraries and information services is never legally neutral. Information professionals must understand how these laws work together, so access can be provided responsibly, lawfully, and sustainably. The 5 key information laws in Malaysia work together to produce several important effects on information management. First, they ensure the preservation of national memory. Through library deposit and archives legislation, publications and records are systematically collected and preserved. For example, books, government reports, and official records are not left to chance. They are safeguarded so future generations can study Malaysia's history, culture, and development. Second, the acts provide protection for creators and inventors. Copyright law protects authors, artists, and content creators. Patent law protects inventors and technological innovation. For example, a researcher's article cannot be copied freely without permission, and a patented invention cannot be commercially exploited without authorization. This protection encourages creativity and innovation. Third, the acts regulate access and use of information. Access is allowed, but within legal boundaries. For example, a library may provide access to digital resources, but restrict copying, downloading, or sharing according to copyright and license terms. Access does not mean unlimited use. Finally, the acts create accountability in information management. Libraries, archives, publishers, and public institutions are legally responsible for how information is created, stored, preserved, and accessed. For example, unauthorized destruction of records or illegal distribution of materials can lead to legal action and reputational damage. Together, these effects show that law gives structure, responsibility, and trust to information management practices. Checkmark Canva AI Voice Tips. Voice. Professional, calm. Speed. 0.95x. Estimated duration. 45 to 55 seconds. If you want, I can. Small Diamond prepare a final closing slide. Small Diamond turn this into a 1-minute summary video. Small Diamond or align it with professional ethics and competencies. The 5 information laws have direct implications for professional practice in libraries and information services. First, legal awareness is essential. Information professionals must understand the laws that govern copying, digitization, records, and access. For example, a librarian who understands copyright law will know when copying is allowed for study, and when permission is required. Without legal awareness, even well-intentioned actions can lead to infringement. Second, policies and controls must be in place. Legal compliance cannot rely on individual judgment alone. For example, libraries need clear policies on digitization, records retention, access control, and use of licensed resources. These policies guide staff and users, and ensure consistent and lawful practice. Third, ethical access must also be lawful. Providing access is a professional value, but it must respect legal boundaries. For example, restricting access to sensitive records or limiting downloads of copyrighted materials is not unethical. It is responsible and lawful practice. Finally, risk management is part of information work. Managing information involves managing legal, financial, and reputational risk. For example, training staff, monitoring use of digital resources, and complying with licenses help institutions avoid lawsuits, penalties, and loss of trust. In professional practice, information management is not just about service. It is about responsibility, accountability, and trust. There are several key issues that information professionals must clearly understand. First, digitization does not remove legal limits. Converting materials into digital form does not make them free to use. For example, scanning a book or archival record and putting it online still requires compliance with copyright, privacy, and records laws. Digital format increases access, but it does not cancel legal responsibility. Second, access must be justified and controlled. Not all information can be accessed freely by everyone. For example, libraries may allow on-site viewing of certain materials but restrict downloading or sharing. Archives may limit access to sensitive records to protect privacy and public interest. Third, libraries and archives are legal stewards. They do not own all the materials they hold, but they are legally responsible for managing them properly. For example, holding a deposited book or public record means the institution must preserve it, protect it, and provide access lawfully. Finally, law, ethics, and access must align. Ethical intentions alone are not enough. For example, providing unrestricted access may seem ethical, but if it violates copyright or privacy law, it becomes irresponsible. Professional practice requires balance. Access must be ethical, but also lawful and accountable. In conclusion, law shapes all information services. Libraries and archives do not operate independently of legal frameworks. Every decision about information is influenced by law. Preservation and access are legal responsibilities, not optional activities. Collecting, storing, digitizing, and providing access to information must follow national laws and regulations. Information professionals play a balancing role. They must support access to knowledge, while also ensuring compliance with copyright, records, and patent laws. This balance is what defines professional practice. Ultimately, professionalism in information management means lawful and ethical action. It means understanding the law, applying it responsibly, and ensuring that access to information is sustainable, trustworthy, and accountable. Thank you.